I'm Jeremy Scahill from Dropsite News, dropsitenews.com. It has been 11 days since federal agents working under the direction of the Trump White House raided the apartment building of Columbia University graduate and Palestinian activist Mahmud Khalil, snatching him and handcuffing him in front of his 8-month pregnant wife. Khalil is a legal U.S. permanent resident, a green card holder, and his wife is a U.S. citizen. They are expecting a new baby any day. Let's look at some of the video that his wife filmed the night Mahmud Khalil was taken by federal officers.
You're going to be under arrest. So turn around.
Okay,
Stop
let's
resisting.
not.
Stop resisting.
Okay, he's not resisting. He's giving me his phone, okay? He's not, I understand, he's not resisting.
Put your arms
Like,
around.
There's no use for this.
Don't worry about it. You're going to have to come with us. Don't worry about
I'm
it.
coming with you, no worries.
No one's resisting, no one's getting worked up.
you guys really don't need to be doing all of that.
It's fine. Maybe it's fine.
حبيبي كيف بدي اتصل فيك؟
Take Amy. Call Amy. She'll be
Okay. Hi, Amy. Yeah, they just like handcuffed him and took him. I don't know what to do.
The Amy that Mahmud Khalil's wife is referring to is Amy Greer, who is one of the attorneys for Mahmud Khalil, and she's going to join us in a moment. But those federal agents took Khalil, a man who has no criminal record, who has not been charged with any crime, and they tossed him into the vortex of the Immigration and Customs Enforcement system. He was initially held in New Jersey, but then was, for a time, effectively disappeared because his wife was looking for him in New Jersey, where he was listed as being held. His attorney was looking for him in New Jersey, where he was listed as being held. But he had been moved to a notorious ICE detention facility in the state of Louisiana. Mahmud Khalil recently published a letter from that prison in which he declared himself a political prisoner. There should be no doubt about it. That is true. And the reason is because the president and the Secretary of State, Marco Rubio, have made clear that this is not actually a criminal case, that they are holding him in ICE custody, threatening to deport him because he exercised his First Amendment, constitutionally protected right to free speech, right to freedom of assembly. The government has not produced a shred of evidence that Mahmud Khalil has committed any crime. They haven't indicted him for any crime. They are going after him because he was a named public leader and negotiator for the student protests against the Israeli genocide on Gaza on the Columbia University campus. They are using him as a test case in a sweeping campaign to dramatically expand the powers of the executive branch, to crush the rights, not just of green card holders or other immigrants, not just of visitors to the United States, but of all of us, of American citizens too, to crush the rights guaranteed under the US Constitution. And that results in a situation where if any of us expresses views that the president and his supporters disagree with, they're making an argument that it's fine to say that there should be an exception to the First Amendment. They should get some lawyers and see what is the process for amending the US Constitution if they believe that. And in this case, they appear to be arguing that the First Amendment doesn't apply to speech when it's critical of Israel, a country that is receiving billions of dollars in US military aid to commit a genocide against the Palestinian people. This is what this case is actually about. Now, Mahmud Khalil's attorneys are engaged in what may well be a precedent-setting case that cuts to the core of key issues surrounding speech in the United States, due process in the United States, the right of any of us to dissent from the policies of the US government, and specifically to oppose the genocidal policies of foreign governments, in this case, Israel. Now, in the meantime, Columbia University itself is being sued by Mahmud Khalil and 7 other Columbia and Barnard students to try to prevent Columbia University from handing over private disciplinary records to the House Committee on Education and Workforce. This congressional committee has zeroed in on several of the protests against Israel's war on Gaza on that campus, and they're engaging in what amounts to a McCarthyite-like crusade to try to crush and criminalize free speech about Israel on college campuses under the auspices of fighting anti-Semitism. Now, the lawyers in this case for Khalil and his fellow students are arguing that handing over these records would violate the First Amendment rights and privacy rights guaranteed to these students by the university and by the Constitution of the United States. It's a tactic commonly referred to as jawboning, where the government seeks to coerce private parties in an effort to punish views that the government doesn't like. And one of the tactics that the Trump administration is using in this crusade has been to cancel or threaten to cancel or withhold federal funding to Columbia and dozens of other colleges and universities. And this congressional task force announced just days before Mahmoud Khalil was snatched by federal agents that it would, quote, conduct a comprehensive review of the more than $5 billion in federal grant commitments to Columbia University to ensure the university is in compliance with federal regulations, including its civil rights responsibilities. 4 days later, on March 7th, the Trump administration announced that it had canceled approximately $400 million in federal grants to Columbia, saying the university had failed to, quote, protect Jewish students from anti-Semitic harassment. Now, there are some new developments in this civil lawsuit, as well as in the deportation case against Mahmoud Khalil. On Wednesday, today, Judge Jesse Furman in the Southern District of New York ruled that the Trump administration's attempt to move Mahmoud Khalil's case and therefore the jurisdiction from New Jersey to Louisiana was unlawful. We don't yet know if he's going to physically be moved back to the New York area, but this ruling is a rebuke of the Trump administration. Judge Furman also kept his order in place that forbids Mahmoud Khalil's deportation as this case plays out. And in that civil lawsuit that I mentioned, Khalil's lawyers are filing a new amended complaint today, and they are adding as defendants in the case the U.S. officials, federal officials in charge of making and implementing these threats against Columbia University. Includes the new defendants, Attorney General Pam Bondi, Education Secretary Linda McMahon, and other federal officials. The lawyers added this to the suit in part as a result of a letter that the government sent to the interim president of Columbia University, Katrina Armstrong, setting out a list of demands for the university to comply with if it wants to continue receiving federal funds. Among these was implementing a ban on wearing masks on the campus that seemed to be singling out protesters, even though they said, well, there's some religious and other exceptions. It's clear that's the intent. It also directed the university to, quote, complete disciplinary proceedings for the Hamilton Hall and encampments. Meaningful discipline means expulsion or multi-year suspension. The university has already started doing this. It also directed the university to adopt a definition of anti-Semitism that aligns with President Trump's recent executive order, and that effectively is an Israel-specific speech code, along with other directives that the lawyers believe are violations of the First Amendment and other rights. We're going to get into all of this right now with one of the attorneys on Mahmoud Khalil's case, Amy Greer from the law firm Detained and Lewis. Amy Greer, thank you so much for joining us.
Yeah, thank you for having me.
So let's start with this. Well, there's two pieces of breaking news today, but let's begin with what is the most urgent case right now, and that is the deportation case against Mahmoud Khalil. Explain to us the significance of Judge Furman in the Southern District of New York, of his ruling that the case needs to be returned back to the state of New Jersey.
Well, I mean, I think that given the facts and the law as they stand, this was the choice that Furman was left with. Even though we didn't know where Mahmoud was over that night, there has been enough information put out by DHS, et cetera, and ICE that's where he was. So I think Judge Furman did with the facts what he could and landed us back into the District of New Jersey. What I think is important is that, he did not transfer the case to Louisiana, which would be away from his entire legal team, and, would just sort of put the case in a very different situation. So I think having the case here in the District of New Jersey, allows the team of ACLU, New York Civil Liberties Union, the Center for Constitutional Rights, and CLEAR, as well as my own firm, Detained and Lewis, to continue fighting on Mahmoud's behalf.
Let's talk about some of the specifics here. Explain for people the argument, as you understand it, that the Trump administration is making as to why it is lawful to have snatched him and hold him under threat of deportation, when in their own arguments they acknowledge that this is not a criminal matter. What law or regulation are they relying on? And really explain the details of it, to defend the notion that they should be able to deport this green card holder married to an American citizen who is 8 months pregnant.
Yeah, so they're using a very rarely used provision of the Immigration and Nationality Act. And if you'll forgive me, I did not pull the number up in front of me, so I don't want to misquote the number. But it's a provision that was actually created in the 1950s as part of the McCarthyist movement in the United States, and was used to try to deport people who the government thought were communists from the United States, and in particular was as the Forward, a nonprofit news outlet, has reported in its own deep dive into the history of this provision, was actually being used against Jewish Americans who were being accused as communists, of being communists, I should say, and to remove them from the United States. And so Mahmoud is the government, the Secretary of State, is alleging the same, that using that same provision to allege that Mahmoud is somehow a threat to American foreign policy. And I will just add that there is absolutely no evidence that we have been provided, or that I'm aware of, having worked with Mahmoud for quite some time now, that could ever bolster or support such a case. We have seen no evidence. We have only seen a lot of social media posts, and we've seen a lot of press conferences. But as attorneys, we have yet to see any evidence to support this claim that Mahmoud is in any way a danger or threat to American foreign policy. And in fact, as I've pushed back in a number of different interviews, framing Mahmoud as a dissident or something like that, Mahmoud is a human rights defender. Mahmoud spoke his conscience as far as defending the human rights and dignity of Palestinian people, but ultimately all people. A lot that gets missed in the framing around the Columbia protests is that it's not just an anti-genocide protest or a pro-Palestine protest, but there are a lot of other human rights related issues woven into that, relating to the community of Morningside, which is immediately around Columbia, and a lot of other sort of civil and human rights related issues. And so this framing is incredibly problematic on multiple levels, and frankly just untrue.
There's been some discussion or theorizing about why Mahmoud Khalil was moved from New Jersey to Louisiana. Do you have clarity, and or do you understand what is your best assessment of why the government so quickly took this guy who lives in New York City, and almost immediately had him in transit to Louisiana? What was going on there?
I mean, we don't know. So I can only speculate, which as a lawyer, I'm always hesitant to do. But, I think it would be hard not to ascribe bad faith actions, or bad faith intent. From what I understand, at 26 Federal Plaza, they had already made the decision that he was going to be going to Louisiana. So before he even got to New Jersey, it had already been predetermined that he would be sent to Louisiana. And I can't help but think that the idea was to move him as far away from me as possible. One of the agents spoke to me on the phone. They were aware that Mahmoud had representation. I had asked to see a warrant. I asked them to send me a warrant. They hung up on me, as you heard and saw in that video. And so one can only think that, knowing that he's represented, knowing that we would be filing something as quickly as humanly possible, that they were endeavoring to move him out of reach, basically, both jurisdictional reach for the courts, but also of my reach, where I didn't know where he was until from 8:30 Saturday night until Monday morning, when he was able to make a call to his wife and then ultimately to me. So I can only guess, but it doesn't seem like it was an effort in good faith.
Yeah, are you concerned, given what we saw? Now, this is a totally different kind of case, but given what we saw recently, where the Trump administration deported more than 200 Venezuelans to a third country, to El Salvador, where both the president of El Salvador and the Trump administration essentially said, nah, 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 we did this, even though a judge literally said, if that plane is on the runway, stop it. If it's in the air, turn it around. Are you concerned that they would, in the dead of night, just decide, who's going to stop us? We're going to deport him, or we're going to send him to Guantanamo?
Right. I mean, I think that's definitely a fear, and that also just happened with the Brown doctor who was a Brown University doctor who was stopped at Logan Airport. There was also a court order there not to send her back to Lebanon, and it was done. I think it's absolutely a concern, and I think that we can't operate in a vacuum here thinking that the rule of law will insulate us completely. Obviously, we would hope that the amount of action that's been happening in this country in support of Mahmoud, including, I might add, from Ann Coulter, that that he should not be deported, that this government may be responsive to some of that public pressure. And at this point, I think that's, other than the rule of law and the public support, that's all we can rely on right now. Whether the administration will comply with court orders, whether they will wait before sending Mahmoud out of the country, I hope they will. And also, like, to your point, he is legally situated differently, where he does have the valid green card. But whether that, again, what with this administration, who knows? we just don't know.
Has the U.S., I mean, forgive me for not fully understanding immigration law, but has his legal permanent residency status been stripped, or is that something that the government, is that something that would be decided in this case? Because Rubio seems to be under the impression that he can unilaterally just say he is no longer, his visa is no longer valid, his residency is no longer valid. What's the status of that?
Yeah, so immigration law is its own beast, and I am not an immigration attorney, so we are working with immigration attorneys, but I will just say a couple of things about that. One thing, just to frame for people who are not aware, because I think there's a lot of confusion around this. In the United States, we have Article 3 courts, like the federal court in the Southern District of New York, that just made this decision about, where the habeas case can be heard. And those are the constitutional courts that you read about when you read our Constitution. Immigration courts, however, are a subsidiary of the Attorney General of the United States. They're administrative courts. They're not, constitutional Article 3 courts. And therefore, there aren't as many protections there for people in the same way that there are when people watch, procedural shows, police dramas and stuff. You'll hear them talking about the rules of evidence. You'll hear them talking about criminal procedure and things like that. Certainly, there are some of those rules in the immigration context, but they're much fewer and slighter. And in some situations, federal courts are actually prohibited from reviewing decisions that come out of immigration courts and the appellate process within the immigration court structure. So I just flag that for people because, this removal process is certainly alarming because there are so many fewer protections in that immigration context. Now, as to the green card, I have been aware from some immigration experts that there have been times in our history where the Secretary of State was able to unilaterally strip a green card, but having to go through the Senate Judiciary Committee in order to do that. So I guess unilaterally isn't the right word, since they needed approval through the Senate Judiciary Committee. But to my knowledge, that is not a common procedure, and obviously should be and is rarely used. So green card holders in the United States are entitled to due process. They can't, the government should not be able to just strip somebody of a green card. They went through a rigorous process to receive the green card, and therefore the government has to present evidence and rationale in an immigration court in order to remove that status. What we're arguing in the habeas case, however, is that his detention and the threat to his green card overall is unconstitutional. It's an infringement on his First Amendment rights, which he has as a lawful permanent resident in the United States, and is, ultimately a political maneuver that should not be allowed to be used as a way to strip somebody of their green card. So as of now, his green card, though they say it's been revoked, there has to be a process for that, and that process has not yet been completed.
Okay, let's unpack parts of this civil case. I want you to lay out in general what the case is, but I just want to reiterate to people that today you're filing an amended complaint, and the amendments in that I'm going to let you explain. But what you're also doing is adding Trump administration officials, appointees, and others who are in charge of implementing the directives to essentially threaten or withhold the funding from Columbia University. Now, you're not representing Columbia University. This isn't about the money. What it's about is the government's use of coercion against a private institution to try to compel it to violate the free speech rights or other liberties of the students or members of that private institution. So let's start first with just the big picture. Explain the civil suit, and then you can add why you've now added these Trump administration officials as defendants in the case.
Sure. So just for framing for context, I had been working with Mahmoud and many other students at Columbia University for quite a few months now in disciplinary proceedings. So I was defending students who are facing all kinds of disciplinary proceedings, typically for their expressed viewpoint. And after watching time after time after time, case after case, and noticing who my clients were, so to speak, who the students were that I was representing, are primarily Palestinian students, Arab students, South Asian, Muslim, students of color, first generation students, and also that all of their viewpoints were either pro-Palestine or anti-genocide or any variation therein, that we started to notice a pattern as to Columbia's enforcement of its rules and also the bending of its own rules. And so as a team, we began drafting a complaint. This was prior to Mahmoud's unlawful detention by DHS, that he and some other plaintiffs who are proceeding under pseudonyms for fear of reprisal and retaliation we have determined that the federal government, through coercive measures by requesting individual student disciplinary records, and now these additional actors from the agency side, from the anti-Semitism task force, withholding significant amounts of contract funds and other funds in order to get Columbia to suppress a certain viewpoint speech. So let's back up. The government, Congress, agents in the federal government, state agents, so your governor, your Department of Education, your state, they cannot impinge upon the First Amendment rights of the citizens and residents of their communities. We know that. We learned that in our civics classes in school. The government cannot infringe upon our First Amendment rights, which are freedom of speech, freedom of expression, and freedom of association. In this particular case, this is what we're focused on. They cannot tell you who you can and cannot associate with. They cannot tell you what you can and can't say unless it's, inciting direct violence, imminent violence, or a direct threat. And the government also cannot use a third party to launder their efforts to infringe your First Amendment rights. They can't say to Columbia or to other entities, we're going to take away your licensing, take away your funding. We are going to hyper regulate you as a way to coerce you into doing our dirty work and infringing upon those free speech, free expression, and free association rights. And that's exactly what's been happening here. Congress has been obsessed with what's happening at Columbia University, as well as a couple of other universities around the country. People may recall the disastrous hearings in the Committee on Workforce and Education in the U.S. House of Representatives in 2024, where two presidents one from Harvard and one from the University of Pennsylvania were essentially forced to resign. And the former president of Harvard experienced death threats and horrific harassment and all kinds of attacks on her scholarship. And then Columbia president came in and basically capitulated, naming students and faculty on the record. And people actually learned that they were being investigated by the university during those hearings. On October 31st, 2024, the committee put out this huge report. And in that report, it's like 360 pages long. There's a whole grid at the bottom of Columbia disciplinary cases and from other schools. And though Columbia complied with FERPA, meaning that there's no student names on there and things like that, they left in enough identifying information that anybody who's been harassing these students, stalking these students, and implementing these pretty horrific campaigns against students, were able to put the facts together and identify those students. And so students, including Mahmoud, experienced escalating attacks that Columbia invited in many ways and did not prevent at all. And so over time, they have clearly become an actor for the government in suppressing the speech of their students based clearly on viewpoint, discrimination and suppression of a specific viewpoint. And to that end, we initiated a lawsuit both against the Committee on Education and Workforce for wielding a cudgel on Columbia in order to force it to comply with its orders and suppress its students' speech. But now we're also adding in the agencies involved in the task force on anti-Semitism, which comes out of the Department of Justice, because they're actually now withholding the funds. So the committee is using the cudgel of individual student disciplinary records, and the agencies are using the cudgel of withholding funds, all to pressure Columbia to turn over identifying information of students, to scale back academic freedom and the right of free speech and association on its campuses, and also to turn over names and associations of students, faculty, and staff that obviously these agencies and the congressional committee intend to use as exposing for exposure's sake, to shame, to potentially, if they have any kind of immigration status that's revocable, to be used in that way. And so we felt compelled to bring this suit.
Yeah, the letter that was, I think, one of the prompts for you to then expand the defendants in this case to include the Education Secretary, the Attorney General, and others that you mentioned. This March 13th letter that was sent by the government to the interim president of Columbia University. I mean, people really should read this. Whether you're a constitutional law scholar or not, you read this and realize that the government is directing a private university to adopt a specific definition of anti-Semitism that, objectively speaking, is really an attempt to try to stifle attempts to have free speech about Israel, and conflates Judaism with Zionism and Judaism with the state of Israel. And then, there's this business about not wearing masks and other things. But really, I mean, this is the thing that just jumped out at me, that they're basically saying, unless you do this, and unless you expel students and engage in other disciplinary activity for First Amendment protected speech, then we are going to withhold funding from this university. They're not accusing the university of like running a criminal syndicate. They are clearly directing the university to implement a political agenda being wielded by the President of the United States under the veneer of legitimacy of the White House.
Right. Yes, and I will add, they want to put a whole department under receivership.
It just happens to be the Department for Middle East Studies, Asian Studies, etc. Right, and explain what that means too, because that's a chilling attack on academic freedom as well.
Sure. So there's a few layers to all of this. So we'll go back to the IHRA definition that they're using. And I will just say that while I don't fully agree with the IHRA definition, when you go to their website, the International Holocaust Remembrance Alliance is IHRA. And actually, when you read that definition, and I'm not necessarily saying people should adopt it, but it actually has been spun so out of control, and it doesn't say what people are now saying that it does. And in fact, over time, the people who drafted it have called out for, that it's being overly expansive now. When I haven't looked at it today, but the last time I looked at it, Zionist did not appear in its definition. So but the way that it's being bandied about and wielded in this case, it basically means that any criticism of Israel of the type that we would make of any any country, would become unlawful or could be suppressed in this country. And as I've written in other spaces when I've been working with students, basically the way that the university has already started to wield this definition is to say that any country that is made up of a specific ethnicity or religious group, has a distinct religious identity. Any speech that's critical of that country is aimed at and critical of the people of that country as well, not just the governments, but it's this big expansive definition. Basically means, as I was laying out for them, that conceivably a country like Germany, who identifies as a white Christian nation, or India that now identifies as a Hindu nation, or Iran, the Islamic Republic of Iran, that any critique of those should fall under that. And yet that's not what we're seeing. We're only seeing it as applied to Israel, which is distinct viewpoint discrimination. And so, that definition, both from Congress, from these agencies, as well as the university's application of it, on all levels, is basically trying to suppress any criticism of a foreign government where there is, a distinct religious identity in the case of Colombia, but as applied really means there can be no criticism of the Israeli government. Additionally,
one point of clarification before you move to the next thing. When I'm referring to a conflation of Zionism with Judaism, or Judaism with the state of Israel, I'm referring to the statements made by the President of the United States, whose executive order is being cited in this. I mean, there is the stated, and then there's the unstated. When you have the President of the United States very clearly directing this attack on academic and freedom of speech, where we know exactly what they mean because they say it out loud what they mean.
Sure. And I'll just point out that our prior president identified very strongly as a Zionist. And so, to say that there's a conflation there, between a Jewish identity and a Zionist identity, when so many people, including sort of white Christian nationalists in this country, are very quick to adopt that Zionist identity, I think makes clear that it's a political position and not it is not that conflation. I will also just point out that a lot of students at Columbia specifically who have experienced profound harassment by both the university and by doxers and other harassers are themselves Jewish, and have proclaimed that what they are calling for and what they are calling out, the genocide, the forced displacement and ethnic cleansing in the occupied West Bank, and so many other actions, they find offensive to their Jewish faith. And yet when they state that out loud, they themselves are also facing disciplinary proceedings. And so that also calls into question, we are now in a situation where our president, our Congress, our federal agencies, and our private universities are actually telling Jewish individuals how to practice their own faith. And if they practice it and they follow their own traditions and their own beliefs, which lead them to an anti-Zionist position or an anti-genocide position, then somehow they are no longer Jewish. And that, to me, and to many that I'm working with, that is in fact anti-Semitic. anti-Semitism. When you tell a Jewish person how they can and cannot practice their religious beliefs, and then in following those beliefs, deeply held beliefs, to speak out, to raise awareness, as happened with, say, Grant Minor at Columbia recently, who was just expelled. To me, those are distinctly anti-Semitic, and yet they are not the ones receiving the protection here. So I agree with that assessment. As to the receivership, for those of us who have lived in cities over the years, we may have had situations where the government has had to take over a school system, where they make hiring and firing decisions. They may make curricular decisions because, for whatever reason, that school district, whether it be for financial reasons or political reasons or otherwise, cannot sort of manage that department for whatever reason. There's a lot to say about that. Basically, in this case, what the government is saying is they want to have effective control over this particular department at Columbia to determine who can teach and who can't teach, what they can teach, what can be spoken about, what can be read. It basically impedes on the basic right of academic freedom in this country, of intellectual inquiry. It's an attack on people who want to expand their knowledge, to come together and associate and challenge each other, engage in rigorous study and debate. The government is essentially saying that it will now come in and run this department and determine who can learn what. For Harry Potter fans out there, I kind of think about it as when I can't think of her name, when Dumbledore had to go away and came in and the state kind of took over. So for a movie reference for anybody out there, that may be an example of sort of what we're talking about. Although this is real life, it's our First Amendment. These are our constitutional rights that they are impeding on, and I hope that people get activated around it, because where Columbia goes, so goes the country, I think, at this point.
I want to ask you, in the time we have remaining, about what comes next for Mahmoud as he remains in this ICE detention facility, which is a notorious facility. People should look into some of the human rights reports that have been written about this facility where he's being held, and also the very powerful letter that was published this week by The Guardian, which I understand he dictated to friends, supporters, and then it was published in the Guardian and elsewhere. But first, I want to ask you, from a constitutional perspective, because this may well go to the highest court in the land. I mean, we don't know yet in this case. For people that maybe think this doesn't affect them, what are the constitutional issues at stake in Mahmoud Khalil's case?
I think there are many. One, I think it is imperative that we understand that when we allow First Amendment rights to be infringed upon with people who are vulnerable in our society, they may not be citizens, and therefore they have positions that are revocable by our government. Or, something this government has made a lot of noise about is naturalized citizenship, and the possibility of rolling that back or revoking that status for individuals here. And so far, the courts have prevented that. But, when we think about our First Amendment rights, we think that they apply to all of us and to all residents in this country, meaning that we can gather with who we want to gather. We can practice our faiths how we want to practice. We can speak about issues of public concern and critique our government. We can express that verbally, but also through expressive speech, through like the art behind me on the wall here. We have these rights. They were drafted by the framers, who we can critique all we want, but they knew to put these particular rights first. These are the first rights that they put in those amendments, and I think that means that they are critical to our, to our fabric as a society. One of the Supreme Court judges, Oliver Wendell Holmes, talked about the marketplace of ideas. That is going to be disappearing. So the effort to move everything toward privatization in the free market may go up economically, but we're seeing that go down as far as speech goes. And so I think what happens with this case is a true bellwether to whether or not we as Americans want to preserve our right to speech and expression and association, or whether we're going to let this administration roll back those rights.
The one of the concerns I have as I've watched this unfold too is the way that in the court of public opinion, and it's being led, directed by the President of the United States, who has the most powerful pulpit in the world, is that it seems to be an attempt to do a backdoor expansion of the material support laws, material support for designated terrorist organizations. I mean, one of the things that sets the United States apart from even European countries is in many European countries, whether it's Germany or elsewhere, there are issue-specific speech laws. And we've seen thousands of criminal citations given to people in Germany since the beginning of the Israeli genocidal war against the Palestinians of Gaza, including Israeli citizens living in Germany who are Jewish that have been charged with crimes of speech for protesting against the genocide in Gaza. And it's something that I think, Vice President J.D. Vance, he goes to the Munich Security Conference, he rails against speech laws in Europe. I actually think he said a lot of things that objectively are true. Now, he may not have been thinking of the examples I'm thinking of, but he said things that are objectively true. And then soon after that, they go after Mahmoud Khalil and they try to deport him. And when they litigate this case on Fox News or on their media ecosystem, they portray, first of all, they do guilt by association. Anything any student did at Columbia University, Mahmoud Khalil is responsible for it, even if there's no direct evidence. Things that were posted on Instagram, even if he hadn't seen them or wasn't even a member of an organization that did it, well, he's somehow responsible for it. But what's most dangerous is that they're implying that he provided what amounts to material support for Hamas in his activism. And one of the things they cite is, well, we have video clips of him defending the right of armed resistance, which, by the way, is the actual right of the Palestinian people. I'm not afraid to say it for any reason, including that it's actually legally protected. But what I'm getting at here is that we've already seen some really disturbing court decisions in recent years that have expanded the definition of what does it mean to materially support a designated terrorist organization. And what I'm sensing here, and this is scary stuff, is that Trump and Marco Rubio seem to be creating a system where they can punish someone for an unprosecuted allegation that they've engaged in material support.
Yeah, no, I think you're right. And this is something that I've been thinking about, and the firm I work for, we've been thinking about on a couple of fronts. The material support expansion, I think, is one arena, and then the other arena is the expansion of racketeering laws and RICO laws being used to prosecute protesters and mutual aid organizations, bail funds. So I agree with you. I think one of the things that that has been happening for years now, this is not new, post 9/11 on the material support front, obviously, and then, post, I would say probably the Michael Brown era in 2014, we're seeing slowly with the racketeering, where the definitions of what constitutes an enterprise in the racketeering arena, and also what constitutes support and materially supporting are expanding. And I think that we should all be concerned about the use of criminal laws and the expansive definitions and interpretations of these criminal laws being used as yet another mechanism to suppress speech and association. And I think the writing's been on the wall. Stop Cop City case comes to mind on the racketeering on the racketeering front. And I think there are too numerous of cases in the material support front to list here. But I agree with you that they seem to be like prosecuting a material support case in a way in the media, or trying to. I think the problem they're running into is that there's actually no evidence. What they're running into now is that the only way to do this is to play a rhetorical bait and switch, because who they're actually dealing with is an amazing human rights defender.
Finally, Amy Greer, because I know you have to go. You have a busy day ahead of you on multiple fronts here. Just give us a sense of what's coming up in the deportation case against Mahmoud Khalil. When is the next hearing? What are the significant milestones coming up?
So I'm not sure when the next hearing will be. The case just got transferred today. Perhaps while I've been talking to you, we've gotten a hearing date. So I'm not aware of that just now, but we're not sure yet. I think, the critical outstanding motions that Judge Furman did not decide on because of the jurisdiction issue is bail, and also requesting that Mahmoud be moved from Louisiana back up here. So those will be the next things that are coming up as far as, hearings and papers and writing and all of that kind of stuff. But when the court will hold a hearing for that, I am not yet aware. So I think we'll see. As to the removal proceedings, which is under a separate body, and whatever, there's a hearing coming up. We're hopeful that nothing really happens at that hearing, and that we can even get an adjournment while we wait for the other judge. But I think all of that, remains to be seen. And so the uncertainty is real. And I think as an attorney, I'm going to give a terrible attorney answer, it depends. There's so many ways this could go right now. I think we're hopeful that the judge will consider, I'm hopeful that the judge will consider attending to the bail question as soon as possible. Obviously, Mahmoud's wife would love to have him back home and supporting her. And of course, we would all want that too, as does his whole community want him back. So we're hopeful that the judge will deal with that as soon as possible. As to the civil case, we'll be filing that amended complaint and a preliminary injunction this afternoon, and are hopeful that we are able to stop the implementation of both turning over the student records and further accosting by the government of Colombia's academic freedom. So hopefully we'll be able to accomplish that in the next 24 to 48 hours.
Amy, thanks so much for taking the time out of what I know is an extremely busy day for you to join us.
Yeah, thank you. It's an honor.
Amy Greer is one of the attorneys for Mahmoud Khalil. She is from the law firm Draytell and Lewis. And that does it for this episode. Make sure to follow us on our podcast feed. You can search for Dropsite News wherever you get it. You can support our work by becoming a paid subscriber. It's not required. We don't put anything behind the paywall, but it is how we fuel and fund our journalism. You can go to dropsitenews.com to read all of our coverage of Mahmoud Khalil's case, as well as on-the-ground reports from Gaza, from the occupied West Bank, from Lebanon, from Yemen, and elsewhere around the world. Thank you so much to all of you for joining us. I'm Jeremy Scahill. Thank you for being here.